Good afternoon, everyone. Welcome to today's webcast, Building Your Case Through Depositions. We are excited to have Quentin Thompson as well as Jeffrey Moore with us today. So we'll get started right now. And let me give you a little bit of an introduction for these gentlemen. Jeffrey K. Moore Jr. is an attorney with Nahon, Saharovich, and Trotz. He is a native of Nashville, Tennessee, which is rare these days, fellow native here. After graduating from law school at the University of Memphis, Mr. Moore worked in insurance defense, litigating auto cases, slip and fall liability cases, security cases, and trucking cases. During his time as a defense attorney, he found that he had a passion for helping people, and as a result, made the decision to transition to personal injury and has since utilized his experience in insurance defense to help his clients reach efficient resolutions in their cases. He also currently focuses primarily on auto accident cases and premises liability cases. Next is Quentin Thompson. He is an attorney devoted to representing the underdog and providing a voice to the voiceless. Mr. Thompson is currently a personal injury litigation associate with Morgan & Morgan's Memphis office, where he deals with auto collisions, slip and falls, and wrongful death cases. He also went to the University of Tennessee, Knoxville, with degrees in business administration and management and psychology as well. So he earned his JD from Vanderbilt University as well. So I will go ahead and let you all take it away. Thank you both.
Well, good afternoon, everyone, and welcome to our CLE. We are excited to discuss depositions with you today, and we're glad that so many of you decided to join us for this very important topic. So I'm going to jump right in on our first topic, which is deposition preparation, because you simply cannot conduct a good deposition without preparing. A lot of times the preparation takes 2-3 times longer than the actual deposition itself. So some of the things you want to review, you want to review discovery answers and produce documents, medical records, prior deposition transcripts, resumes, CVs, published opinions if you're deposing an expert, reports, including police reports or any other type of incident reports if it's a torts case, and other similar related documents. So first, talking about preparing to defend. So one of the things you have to do is that you have to prepare your client or prepare the witness if it's your witness that will be getting deposed. So we just put down a few key things that you need to do when you are thinking about defending a deposition. So for me, I am a plaintiff attorney, so a lot of my examples and my experience will come from the plaintiff side. But I do, of course, know many defense attorneys, so I know their process as well. So I'll try to talk about both sides and maybe talk about things outside of personal injury as well for those of you that may deal with other types of cases. But one of the things that I always do is that I want to refresh the witness's recollection of any previously filed documents. So if they answered discovery questions, I want to remind them what they said, because we all know that whoever is deposing that person will be looking for inconsistency. So you want to make sure that everything is in line. You want to review any relevant documents with the witness, like medical records. So for a personal injury case, sometimes my client has a small stack of records and sometimes they have a huge stack of records. So we want to go through those records to make sure that what they believe they say is what they actually say, because that's not always the case. Because sometimes people say they told their doctor A, but the doctor put down B, C, and D. So we just want to make sure that everything is in line with what they believe. And for personal injury cases, you want to look at records before the incident, because a huge defense in personal injury cases is always, well, that was already there. That's pre-existing. So we want to make sure we go through what their prior medical history was to combat or, you know, go against any defense about that already being there before the accident. And you want to make sure the witness understands the purpose of a deposition. Let them know this is the one and only time the other side gets to question you about this case. I always go over tips such as don't volunteer extra information, listen to the question that is being asked and only answer that. And then I try to give them feedback throughout a mock deposition, just kind of let them know, you know, how that answer is coming off, because sometimes people can say things that even though it's the truth, the way they're framing it or saying it can be interpreted in a way that goes against them. So those are some things that you want to think about when you're preparing to defend. And then preparing to take a deposition, it's a similar process, but you know, it's going to take more preparation because you are the one on, you know, you're the one that actually has to ask all the questions. So you want to research the person you're deposing. So for example, if I'm researching the defendant in a car wreck case, I may pull their criminal record history if I can. I may you know, just search them online, see if any social media findings come up. You also want to review their answers to discovery. For example, if I asked them the question about the speed of the vehicle and they said one thing during discovery and said something else during the deposition, I want to be able to point that out if I think it's important for me to do so during the deposition. And then before you take a deposition, think about what is the goal for this witness? Because we all know that for the most part, not one thing proves a case or helps you defend the entire case, but it's usually a combination of things. So what are you trying to get out of this witness? So for a defendant, it may be I'm simply trying to nail down liability. If I'm deposing a doctor, I'm trying to get this doctor to relate all of my clients' medical records and bills to the incident that occurred. So once you figure out what your intention is with the witness, then that can help you create an outline. And you don't have to write down every single question you want to ask. If there are some of you out there who haven't taken many depositions, I do know people that do that starting out, but eventually you want to get to the point where you have an outline of the top 3 to 5 things you want to get out of this witness. And then you just kind of want to make sure that before you ask your last question, you have accomplished everything you wanted to get out of this witness before completing the deposition. And then you want to identify any potential exhibits. So after you looked at everything, you did all your research, what, if any, exhibits do you want to bring up during the deposition? Do you want to make the discovery responses an exhibit? Do you want to make the police report an exhibit? Or if it's a breach of contract case, the contract? And then go ahead and have copies of those documents ready to be introduced during the deposition. You shouldn't have to dig through a bunch of documents to pull it out. You know, go ahead and have your copy, have a copy for the deponent and the lawyer. So that way everybody's on the same page, everybody can see it, and make sure you give it to the court reporter, mark it as an exhibit, and go from there. So when you think about preparation, those are just a few tips that we have as you go into taking your next deposition.
All right. I want to thank TBA for allowing me to present today. My name is Jeffrey Moore, as previously stated. Quentin, I think you're controlling the slide, so I'll just say slide when I'm ready to move on to the next one, okay? All right, so most depositions in Tennessee are taken with substantive objections reserved. And so only objections to the form of the questions are made at the deposition itself. And I'll cover what form objections are here shortly. But it's important to note sort of the rationale behind this is that form objections are objections that can be cured and fixed in the moment. So if you're defending a deposition and you're making a form objection, you're objecting to the form of the question, whether or not it was a leading question when the person taking the deposition does not have the ability to lead, or whether or not it's a compound question, or whether or not it's argumentative. These aren't substantive objections. These aren't objections based on privilege or objections based on some statute that won't allow the evidence to come in, or a hearsay objection. Rather, these are objections to the way the question is asked. So when a opposing attorney, or when an attorney who's taking the deposition hears a form objection, it's their signal to either re-ask the question, think about what the objection actually is in terms of what the form objection is, whether it's a compound objection or something of that nature, and then change the way in which they ask the question. The reason why these objections are waived if they're not made is because you're given the opportunity to make them during the deposition. And if those objections are made correctly and the opposing attorney who's taking the deposition understands what the objection is, it gives them the opportunity to cure the way in which they ask the question. With respect to substantive objections, a lot of the time you won't really see those objections until a motion in limine comes into play. Those objections aren't usually made during depositions because they're not waived. So you can make those objections later before trial. And most of the time you see them in the form of a motion in limine. Slide. All right. Objections to form must usually be made, as I said, at the deposition, because the goal is essentially to allow the other attorney to fix the way in which they're asking the question. By definition, the stipulation provides that all objections except those as to the form of the question are reserved. A failure to object to the form of the question, as I noted previously at the deposition, results in a waiver of the right to raise an objection as to the form of the question when the deposition is later used in a hearing or trial. When the examiner hears an objection to form, he or she must rethink the question and A, evaluate whether the objection is appropriate, and B, if the objection may have merit, determine how to correct the question to make it proper. Slide. All right, here's an example to some degree of form objections. And I won't go through all of them, but I'll go through enough of them. But generally speaking, these are the type of form objections that you will be making and that you'll hear made, whether or not a question is vague. The question might be too long. Some of the key words in the question might have more than one meaning. And so it may result in a vague objection. As I noted previously, the compound objection, that's when you're asking two questions. Did you find the canceled check on the ground and take it with you? Those are two questions. And so you would make an objection to that because if the witness is saying yes, then you would assume that they're saying yes to both. Argumentative. These type of objections are essentially made not necessarily to ask a question, but rather to make a statement to the deponent. So I'll give you an example. If the question was, when you arrived at the deposition this morning, had you already decided not to give me your full attention? That regardless of the answer, the rationale behind asking that particular question is not about getting a response. It's more so making it known to the deponent that the attorney believes that they're not giving the full truth. So you would make an argumentative objection there. One that tends to come up rather regularly is misstating the evidence, misstating the testimony that was said previously. So for instance, if the question contains a factual assumption for which there is no evidence in the case, or the question incorrectly quotes or paraphrases when the witness has testified in the deposition, you would make that objection. It's important to note because, again, if you don't make the form objections at the time, then they are waived. And these objections can be very helpful because if you're not making them and if you're not paying attention during the deposition, the opposing counsel can solicit testimony that could be damaging. One that comes up rather regularly as well is asked and answered. And generally speaking, you'll see this when opposing counsel is attempting to get information from the witness, from the deponent, but the answer that they're receiving is not the answer that they want. And so they'll continue to ask the question in order to elicit a response that is consistent with what they're trying to do in terms of developing their case. And so you need to be on the lookout for that, for those type of tactics, so that you can ensure that that there's not any testimony that is improperly undermining the valuation of your client's case. Slide.
So the next topic is noticing a deposition. Form objections are definitely something that if you're just starting out, it kind of takes some time to get used to it, because if you did mock trial or anything like that, you're used to objecting to relevance and hearsay, but like Jeff said, with depositions, you're not doing that. So definitely all great advice that Jeff just went over. So when it comes to notice, this usually can be done either by agreement, or sometimes if you don't have somebody responding, or maybe it's somebody that's not represented, then you will file a notice. Even for me in my practice, whenever it is by agreement, I still file a notice just to make sure that you have a clear record. So as soon as we say, hey, we're going to do depositions on May 19th, I'm going to go ahead and get that notice out. So Rule 30.02 tells you how many days in advance you have to get the notice out, what has to be included in that notice. So it talks about, 5 days, but it could be 7 days if taken outside of the county. But you definitely want to make sure that if you are taking a deposition, get that notice out, because that way no one can dispute, they weren't aware that we were doing depositions on such and such day. And if the deposition comes and the person doesn't show, you can take whatever type of adverse actions are available to you under the Tennessee Rules of Civil Procedure.
All right, Tennessee Rule of Civil Procedure 32.1 is essentially the rule that governs the use of depositions in court proceedings. And there's the rule there. I'm not going to read it out for everyone, but you should have it in your written materials. It's important to note as an initial matter that there's a lot of important information with respect to this rule. And we're going to go through that information slide by slide, but I want to start by noting that the rules of evidence are incorporated into this rule. And so if you look at the initial paragraph at the trial or upon hearing of a motion or an interlocutory proceeding, any party or all of a deposition, so far as admissible under the Tennessee Rules of Evidence, applied as though the witness were then present and testifying, may be used against any party who is present or represented at the taking of the deposition, or who had reasonable notice thereof in accordance with any of the following provisions. So it's important to note that you're already looking at this rule consistent with the rules of evidence, with the lens of the rules of evidence. So any deposition must be considered in light of the rules of evidence as if the deponent were present in the courtroom.
So one of my favorite ways to use depositions at trial is for impeachment purposes. You see Rule 32.01 states that any deposition may be used by any party for the purpose of contradicting or impeaching the testimony of a deponent as a witness. So you'll also kind of get some trial tips throughout this, because the reason you take a deposition is to prepare you for trial. So hypo says a witness testifies at trial that the traffic signal was green at the time of the accident, but testified in their earlier deposition that she did not know the color of the light at the time of the accident. Her deposition testimony can be used to impeach her testimony on the witness stand. So you just want to make sure that first you establish at trial that she is testifying that she knows that the light was green. And then you'll kind of go through a proper impeachment, because sometimes people just said, well, you told me during your deposition that you didn't know what color the light was. You have to actually go through the steps of doing a proper impeachment. So you'll say, is it your testimony today that the light was green? Do you remember giving a deposition on November 15, 2022? If I pass you a copy of that deposition transcript, would you recognize it? So you pass it to them, you have them identify it. and then you turn to the exact page and line number. And that's important because you need to let opposing counsel know what line and page number you're on, and then you need to let the court reporter know. So you say, turn with me to page 32, turn to line 15, read the question as written, read the answer as written, and then say during trial, did I state that correctly? So if they actually said during the deposition that they didn't know what color the light was and they just lied in open court that the light was green, you have now successfully done an impeachment. So definitely be on the lookout for that as you use your depositions at trial for this purpose.
So the use of party depositions, according to the rule, you can use them for any purpose. And that's the language, that's the text. It's important to note, as I noted previously, that we have to look at this rule within the lens of the rules of evidence. And so typically any purpose is generally speaking more so contradicting and or impeachment, as Quinn noted. But you could also use depositions of a party witness. And it's important that we qualify that it is a party witness. This isn't, the rule isn't speaking to depositions of everybody. Specifically, if you are a party in litigation and you took a deposition, then your deposition within the rules of evidence, within the confines of the rules of evidence, can be used in these particular ways. So contradicting and or impeachment as an initial matter, but also proving an element of a claim or establishing an affirmative defense. The way in which this is usually done, and the rule gives control over the presentation of those depositions, is either one of two ways. One, it can be read into evidence, or a second way is if there was a videographer at the deposition, which strategically may be done for a number of reasons, then you can also use that video as a way of using the deposition at trial.
So limitations on using depositions at trial. So as you see on the screen, Tennessee Rule of Civil Procedure 32.01 provides that a deposition may be used against any party who was present or represented at the taking of the deposition or who had reasonable notice thereof. Another hypo, assume A sues B and they depose X, an out-of-state witness. B then asserts the fault of C, who is added as a defendant by A. Can either A or B use the deposition of X at trial if the testimony of X is adverse to C? So from looking at this rule, we know C did not have an opportunity to be present to ask their own questions. So most likely you will not be able to use this against C. Now, if you look at the rules, there are ways to remedy this, because maybe you had early litigation and you took this deposition early on. Well, you can give notice to C that you plan to use that deposition at trial. And that way, if C wants to go and try to either, review that deposition beforehand and see if there were any other questions they would have asked, or maybe if they want to try to quickly get that deposition set before trial so they can ask their own questions, they'll be able to do that at that time.
I'm sorry.
Mm-hmm.
All right, Rule 32.01. So subsection 3 provides that the deposition of a witness, whether or not a party, may be used by any party for any purposes if the court finds that the witness is unavailable as defined by Tennessee Rule of Evidence 804 subsection A. Now we're going to explain 804 subsection A in the next slide, but generally speaking, it permits the use of prior testimony in instances where the witness has died, cannot attend trial due to an illness, where the witness is more than 100 miles from the place of civil trial, or where the deponent of the statement is unable to procure the witness's attendance by process. This last portion here, and in fact, these are typically the normal ways that you'll see this occur, the most frequent ways that you'll see this occur, are these ways here listed. The last portion where the proponent of the statement is unable to procure the witness's attendance by process, that typically happens in one of two ways. One, generally speaking, is that the witness is statutorily exempt from subpoena. So you can't subpoena them because under statute, they don't have to attend. They're not compelled by a subpoena to attend trial, but they are compelled to attend if your subpoena, if the subpoena is solely for a deposition, that's one thing, but you can't subpoena them for trial. But the other instance that you would see this is if you just aren't able to compel somebody to come to court. If they just decide they're not, regardless of order of court, they're not going to come to trial. And so you could have them declared as unavailable. And we'll go through sort of the specific instances that the statute outlines or that the rule outlines for an unavailable witness.
So here are the 6 instances where you do have a Rule 804A issue, meaning that this person is unavailable. And then for all the evidence people out there, you also know this is a potential exception to hearsay as well, if some of you are thinking about a hearsay objection. But you have is exempted by ruling of the court on the grounds of privilege from testifying concerning that subject matter of the declarant statement, persists in refusing to testify concerning the subject matter. Number 3, demonstrates a lack of memory of the subject matter of the declarant statement. Number 4, is unable to be present or to testify at the hearing because of the declarant's death or then existing physical or mental illness. Number 5, is absent from the hearing and the proponent of a statement has been unable to procure the defendant's attendance by process. And you have to go look at service of process for that rule, because you'll have to kind of exhaust all of your remedies through that before you'll be able to use number 5. And then number 6, for depositions and civil actions only, is a greater distance than 100 miles from the place of trial or hearing. And then it says a declarant is not available as a witness if exemption, refusal, claim of lack of memory, inability, or absence is due to the procurement of wrongdoing of the proponent of a statement for the purpose of preventing the witness from attending or testifying. So this is dealing with all of the, trying to threaten somebody not to show up to testify about something, or things that you probably see on TV when you watch a Law and Order and things like that, witnesses disappearing. So you can't actively cause the person to be unavailable, is what that last one is talking about.
Okay, so going back to subsection 5 of the Rule 804, where a witness is absent from the hearing and the proponent of a statement has been unable to procure the declarant's attendance by process. As I noted previously, this can happen, and generally speaking, it happens in one of two ways. You have the statutorily exempt witness. Those are witnesses who, under statute, you're precluded from subpoenaing to trial. And so you can't subpoena them whatsoever, and you shouldn't, because if you do subpoena them and they file a motion to quash, then you could be on the line for any attorney's fees associated with that motion. And now note that Tennessee Rule of Civil Procedure 4505 subsection 2 does provide a slight exception. So upon affidavit of a party or the party's attorney that the testimony of a witness is important, and that the just and proper effect of the testimony cannot in a reasonable degree be obtained without an oral examination in court, the court may, in its discretion, order the personal attendance of the witness, although such witness may otherwise be exempt from personal attendance. Now, I haven't seen any case law at the appellate level where this was reviewed, but presumably you would need to notice or give notice that you would be subpoenaing any witness that's typically statutorily exempt, to allow them to file a motion to quash. You probably have to give them adequate notice. It probably wouldn't just be sort of the normal time frame for giving notice, but ultimately you would have to give them time in order to file a motion so that the court could consider it and rule on it. As I noted previously, another instance in which you would see this occur is with respect to a witness who simply just doesn't show up. And ultimately, in those particular situations, you can have either one be deemed as a witness that is unavailable. And then the last one is the long distance witness. This witness is one that's living 100 miles away from the place of hearing. Now, this is at the time of hearing. Generally speaking, this is you're usually already aware of this when you're taking their deposition. So ultimately, if they're not going to be able to come to trial because they live 100 miles away, then you would want to go ahead and note that during their deposition. And generally speaking, the court would presume that they haven't moved since the time of their deposition. And that's usually an easy way of doing that. Otherwise, you want to get an affidavit from them stating that they live where they live and that's 100 miles away from the place of hearing.
So going into a little bit more detail about witnesses who are exempt from subpoena power at trial. So first, before I go through this list, it's important to know that this is Tennessee state law. So if your case is removed to federal court, or if you are the defense attorney that removed the case to federal court, this may not necessarily apply to that case. Or if you practice in multiple states, this may not apply to Mississippi or Kentucky. There may be some overlap, but this is a Tennessee statute. So do not just assume that if you're in federal court that one of these people listed on here are just automatically unavailable, because it may not be the case. But you have an officer of the United States, an officer of this state, an officer of any court or municipality, the clerk of any court of record other than that in which the suit is pending, a member of the General Assembly while in session, or clerk or officer thereof, a practicing physician, physician assistant, advanced practice registered nurse, psychologist, senior psychological examiner, chiropractor, dentist, or attorney. All of that comes up quite a bit in my practice, as well as Jeff's practice. A jailer or keeper of public prison in any county other than that in which the suit is pending. A custodian of medical records, if such custodian files a copy of the applicable records and an affidavit with the court and follows the procedures provided in Title 68. A licensed clinical social worker as defined by the statute there. And if the court grants a motion to quash a subpoena issued pursuant to subsection A, the court may award the party subpoenaed its reasonable attorney's fees and expenses incurred in defending against the subpoena. So usually, if you are reaching out to these people, they are aware that they don't have to come to trial or come to a hearing, but they'll usually tell you that. So then you have to, figure out how to get their testimony another way, which is the next part we're about to go to when you're talking about proof depositions. And I see some of you asking about the PowerPoint, and yes, the PowerPoint will be available. The TBA will send that out to you. So we will send this out.
All right, Rule 32.01, subsection 3 describes when a deposition can be used for proof under the former testimony hearsay exception. Except with respect to some experts, a deposition is admissible as substantive evidence at trial if the deponent is unavailable to give live testimony. As we discussed previously, the different ways in which a witness can be unavailable. There are times when a deposition is taken fully contemplating that it will be used for proof at trial because it is known the witness will be unavailable at the time of trial. This generally, in my practice, comes up with doctor's depositions. As you saw in the long list that Quentin outlined previously, you can't subpoena a doctor to trial. And so what you typically have to do is either take their deposition as an evidentiary deposition and then read it into proof, or you have to record them, which is typically what we do, or what I do in my practice is if I am taking an unavailable witness deposition, such as a doctor who's also an expert witness, then I'll go ahead and have a court reporter and videographer. You always are going to have a court reporter, but I'll go ahead and have a videographer so it can be recorded. It's important to note that ultimately, if there are any objections to the testimony in a videoed deposition, that there's a process through which they're able to edit the video so that whatever portion doesn't come in based on the court's ruling is edited out of the video. And so that's how they would normally do that. If it's written, if it's a deposition that you're just trying to enter into evidence, then you would just edit those portions out accordingly. But generally speaking, with respect to the video, that's how that process would proceed. The witness may enjoy a statutory exemption from trial attendance, as we noted previously, be out of trial subpoena range, incarcerated, or in poor health and unable to attend court. So again, there may be instances where you're well aware that the witness is not, that you can't call them to trial. And so in those instances, you have to prepare accordingly, whether that be you recording the deposition or if you're prepared to enter it into trial by reading it into evidence.
So talking more about proof depositions. So I know we titled this the do's and don'ts. One of the don'ts is a lot of times we get very comfortable and kind of informal when we're taking depositions, because if you are an experienced litigator, you can be in multiple depositions every week. And a lot of times it may be okay to depose the defendant with kind of like this conversational, informal type of tone. But what you have to remember for proof depositions is that you are taking these with the purpose of using it at trial. So how you come off during this deposition is how the jury will see you or how the judge will see you. So these are the most important depositions you can take, because you know, with other depositions, you have time to figure out things, fix things, and then you know that this person can come to trial. You could ask them questions that you didn't really follow up on during the deposition. But for proof, this is it. So this is what you will be using. So if you didn't ask the question, if you didn't correct it when that objection was made, and unless you all have reserved objections, that could be very detrimental to your case. And then another point says the foundation for proving the witness is unavailable should be developed in the deposition, since the proponent of using the deposition has the burden of proving unavailability. For example, establish that the witness plans to continue to live and work in Atlanta, Georgia, to prove she is outside trial subpoena range. So you can't just go in court and say this person is unavailable. You have to put forth some effort in proving that, because the default will be is that the judge will want the person to come to trial to be examined by the judge or the jury. So it's up to you as the person saying that this person is unavailable to prove that. And you don't have to do much to prove that. Like, this is just asking the simple question, do you continue to live and work in Atlanta, Georgia? And pretty much if the person is currently living there and they plan to continue living there, you've met that burden. So it doesn't take too much. And then looking at Rule 27 says it provides a mechanism for the court to grant a petition permitting the taking of a deposition to perpetuate the testimony of a witness prior to the initiation of a lawsuit. So this is usually in some kind of emergency situations. There may be a strong chance that this person will not be available for trial for whatever reason. So you can kind of speed up the process and go ahead and get the deposition done. Just go back and read Rule 27 and see if you have an issue where this rule applies. But it talks about terminal illness is going to be one of the most important ones. I know I've had a case in the past where the witness was dying from cancer, and we weren't sure how long that person was going to be around. And then we did need that testimony because it was crucial, because it was a disputed liability case. So if you ever have that issue, just go and take a look at Rule 27.
So an expert can base an opinion on facts or data that is not admissible in evidence, as long as it is the type of information reasonably relied upon by experts in their field. Now, Tennessee Rule of Evidence 703 allows an expert to offer opinions at trial based on information gleaned from deposition testimony. Just because the expert can rely upon a deposition testimony does not open the door for the deposition testimony to be read to the jury, assuming there is no independent basis for its admissibility. Again, you be well aware that you're looking at the deposition through the lens of the Tennessee Rules of Evidence. Tennessee Rule of Evidence 703, as originally enacted, prohibited the proponent of expert testimony from disclosing to the jury information relied upon by the expert that is not independently admissible. However, a 2009 amendment incorporated a limited exception, allowing the disclosure of otherwise inadmissible evidence by the proponent of the expert testimony upon a determination by the court that the probative value in assisting the jury to evaluate the expert's opinions substantially outweighs the prejudicial effect.
So another rule to remember is the Bierman rule. Rule 32.01 of the Tennessee Rule of Civil Procedure provides that depositions of experts taken pursuant to the provisions of Rule 26.02 subsection 4 may not be used at trial except to impeach in accordance with the provisions of Rule 32.01. So basically, for those of you that may not be familiar with this rule, you have proof depositions, and then you can also have discovery depositions. So if it is a discovery deposition, that's not necessarily a deposition that you can take of that treating physician or whoever it is that's unavailable, and just take that to court and just play it or read it like you can a proof deposition. If you are doing this for discovery purposes, then that is the reason you are doing it. It's not for trial purposes. But if it is for trial purposes, you know, we always make that very clear in our notice. It says notice of evidentiary deposition. It also says that it will be taken by audiovisual means, so that everybody is aware that this is a evidentiary proof deposition and we will be recording it, because I found that playing the video, if the person can't come to trial, is better than the attorney trying to read the transcript or have somebody sit on the witness stand and read the portion of the doctor. It's better, and the jury likes it better if you actually have a video and they can just sit and watch and hear the doctor say all these complicated medical terms in their own words, instead of somebody you brought from your office butchering every other medical term. So that's just something to keep in mind when you're talking about these type of depositions where people are unavailable.
Be sure to consult the local rules. As an initial matter, most local rules and scheduling orders require the disclosure of witnesses before trial. It's important to be aware of that. Be sure that you disclose witnesses you intend to call via deposition at the time you disclose the witnesses who will be testifying at trial. Witness is a witness, whether or not his testimony is presented live or via deposition. So it's important to ensure that you consult the local rules. While there are consistencies amongst a lot of the counties, there are marked distinctions. So be sure, to be aware of the timelines associated with that. Local rules require that depositions be used at, many local rules require that depositions to be used at trial must be filed before trial. Determine what the local rules are for the venue where you will be trying your case and follow it. So for example, local rule 29.01 of the 20th Judicial District requires 10 days notice of the intended use of audio or visual recordings, including depositions. Under this rule, adverse counsel is also permitted to review the recording in the form to be offered at trial. If the local rules or the court standard pretrial order do not establish a deadline for serving designations, it's a good idea to request a deadline to ensure the objections are resolved prior to the beginning of the trial, and edits can be made when video depositions are used, as I noted previously. A lot of times, a scheduling order will take care of a lot of this, and that might be entered in limited capacity just before trial in terms of what needs to be done leading up to trial after discovery is taken and depositions are completed. But generally speaking, you want to be aware of this, even if there isn't a scheduling order. And you certainly want to be aware of the local rules, because if you're not, and you're not acting consistent with them, then it could opposing counsel could potentially object to your usage of the deposition because you weren't acting consistent with the local rules, and that's a discretionary decision. So you want to be aware of this and act strategically to ensure that you're acting within the best interests of your client.
And And be sure to consult local rules is something that is important for depositions, but it's important for every single thing, motion practice, because there are just so many random local rules out there. And I guess it's a blessing and a curse that you may be able to have cases in different jurisdictions, but something I think I can get away with in Shelby County may not fly in Tipton County. And then it's also a good practice to just file a notice of the transcript, so to go ahead and make the transcript a copy of the record, whether or not they require that or not. I actually do that in my typical practice, because you always want to be creating a good record for appeal. For any of you that maybe took some type of appellate classes in law school, you want to try to have as many things already in the record as possible, so that there's no confusion if something has to go up on appeal. But the final kind of 10 tips we have here about depositions. So thorough preparation. Like I said, you need to prepare as much as you can. And the more you prepare, the easier that deposition will be. And the same is true for trial. Active listening. So that's why I said you really want to think about what your intention is for the deposition and come up with just a mini outline, because that way it will allow you to listen to what that witness is saying instead of worrying about what your next question is. You have professionalism and respect. For the most part, this is not an issue, but every now and then you get attorneys that are not abiding by the rules of civil procedure. Jeff clearly told you all earlier that object to form, and he told you the type of form objections you can make, but a lot of times people go way outside of that. They start coaching the witness, they start answering for the witness. So you have to respectfully shut things like that down, and you have to let them know if we can't get some type of agreement on this, then we need to get the judge on the phone, or I'm gonna have to file some sort of motion to get this before the court, because you do not understand how these depositions work. You want clear and concise questioning. I can't tell you how many times I ask a bad question and I'll say, let me rephrase that. So if I don't understand the question I just asked, they're not going to understand the question you just asked. So it's fine for you to say, let me strike that from the record. Let me please rephrase that question. And then I always tell my witnesses, don't be afraid to do that as well. I don't want you guessing what you think the question is. You need to know for sure what the question is so you know how to answer it. Of course, using open-ended questions, review and address objections, strategic use of exhibits. So everything does not have to be made an exhibit. I mean, a lot of things are already a part of the record. But if you did think that the use of that document was important and you don't want to have to go and look it up, it is nice just to have it at the back of the deposition as an exhibit. Handling difficult depositions. One of the things I talked about was opposing counsel can be difficult, and then you just have to, deal with that accordingly. But you can also have difficult witnesses. So you just want to deal with that the best you can, but the same processes are available. If it's somebody refusing to answer a question, usually the attorney that's representing them can get involved and let them know that you have to answer unless I tell you not to. Or if it's an issue that attorney can't handle, you may have to file any type of proper motions. Remember what we said about proof depositions when it comes to experts and unavailable witnesses, and not to be informal. Make sure you are the way you want to appear before a jury or a judge, because that's exactly what they will see. We are moving to this remote or virtual deposition realm. So, kind of always be prepared when it comes to that. So one of the things I do for virtual depositions, if I want to kind of share exhibits, I'll have a bunch of tabs up on my screen, so that way I don't have to go and hunt for what I'm looking for. Be able to adapt to remote or virtual depositions with, all of the same practical tips that we talked about today. And then don't be afraid to reach out to us for questions, reach out to partners at your firm, members of the Bar Association, a lot of experienced lawyers with the TBA who have a lot of experience with depositions. The TBA YOD this year, we did a
understand.
I don't know why my Siri keeps saying that. But the TBA YLD this year did a great job of creating this welcome basket that has a lot of kind of form documents on there. So that there may be some motions in there you want to look at. You can go to the TBA YLD page and just see if there's something helpful to your litigation practice in there. Jeff, you had any other thoughts on any of these tips?
Yeah, well, I'm just, I guess, repeating everything. I agree with everything that you just said. And then on top of that, note that on the civil side, 95% of these cases in some counties are settling. And so in terms of depositions, if you're a litigator, it's on the civil side anyway, for the most part, it's the closest that you're going to get to being in a trial, especially when it's in evidentiary deposition. So it's also a way for you to cut your teeth in terms of litigating. If you're not given the opportunity to try a case in your initial practice. I will also note for you, and I think regarding the Bierman rule, because I'm not sure if we made the final point, which is that if you're taking a discovery deposition of your opponent's expert, so if you're a plaintiff taking the defendant's expert's deposition, anything that's said in that deposition can only be used to impeach the witness, and that's it. Now, that's a rule that is specific to Tennessee. It's named after the famed attorney, the Memphis attorney, Leo Bierman. The underlying policy for that rule is that ultimately, when you're taking an expert's deposition, it's typical that you'll get a lot of information that might be hurtful to your case. And so the rule is supposed to protect the attorney taking the deposition against the opposing counsel using any information that's found to undermine the valuation of their case. I'm not sure if I said that in a way that makes a great deal of sense, but ultimately, if you're taking the deposition of the opposing side's expert witness, the only way that the opposing side could use that deposition at trial is if they are trying to impeach the expert. That is it. Ultimately, they can't use it as a proof, a deposition. It can only be used as a discovery deposition. But also, if you're taking your own expert's deposition, then that doesn't apply at all. So if you're taking the evidentiary deposition of your expert because for whatever reason, maybe they can't appear in trial because they're a doctor and so you can't subpoena them, then it's as if you're in trial, and they can make objections, and well, they can make objections either way, but it's like you're in trial, and ultimately they can use that deposition for whatever purpose consistent with the rules of evidence. So just in summation, if you are taking an expert deposition of the opposing side, it's counted as a discovery deposition solely for the most part, but can be used to impeach testimony at trial.
And one of the last tips I'll add, and then you all feel free to go ahead and type any questions you have in the chat. I see Jennifer just shared the welcome basket with you. A lot of great information in that. But I help train young attorneys who come to my office about taking depositions. And one of the things I tell them is have fun with it. I mean, there's a reason why we're not bound by the rules of evidence. You know, the only thing you can really object to is objection to the form of the question, and you have a very broad range of what you can talk about as long as it could lead to possible, relevant information. So that's why it's almost not necessary to go in there with all these things that you have to be so structured and regimented. So this active listening is really key. You know what your points are, what you need to get out of this witness, but don't be afraid to explore. If that person says something that piques your interest, start asking questions about that. Sometimes I hate when I know I have good defense attorneys on the other side because my client just said something. It made me interested. I know it's going to make them interested. So now the deposition is 30 minutes longer because they brought up something that they shouldn't have brought up in the first place. And Jeff is right. It's fun going to trial, but unfortunately, or fortunately, depending on which way you look at it, we just don't do that much. So really, this is your way to train yourself and like hone those litigation skills, because you really may not be going to trial that much, and if you do go, they are few and far in between. So definitely, prepare, go in there with your goals, listen, and just have fun with it, explore. And then the more you do that, you will just become this expert deposition taker or defender if you are utilizing the do's and don'ts that we talked about here today. So I know it's 12:55, so if there are any questions, you all can put them in the chat. But I have enjoyed this, and this has been really fun. That's all. Let me see what this says. Yeah, so Jennifer says, feel free to ask your questions here, so you can put them in the chat. Any last words from you, Jeff?
No, thank you for having me.
Thank you, Quentin, and thank you, Jeffrey, for joining us today. Oh, we have a question.
Let's see, it says, any tips for dealing with slick, hostile witnesses? So that's when your research will come into play, because you really want to anticipate what you think the witness is going to say. So that's why if you have those key documents ready to kind of impeach them or question their credibility any kind of way, you want to be able to do that. And then sometimes, it kind of depends on what your style is. But if somebody, is just being, let's just say, a smart aleck, I was going to use another word, but if somebody is being a smart aleck, sometimes you have to give them an opportunity to let them know that they don't know as much as they think they know. So I may start asking questions, and then eventually lead them down this rabbit hole that they can't get themselves out of. But I think it's all different kinds of ways on how you handle that. But the more you can have documentation to support whatever it is you're trying to get them to say, so that you can impeach them even during a deposition, even if they are hostile, it's kind of hard for them to go against that.
And we have one from Jay Mosley. It was, what was the most difficult lesson you learned as a young lawyer performing depositions? Just the need for preparation. You may feel after you've done several depositions that it's just a matter of walking in there, but that has never been. I would counsel against that. I've seen on multiple occasions where you didn't spend the proper amount of time with your client before they went into a deposition, that things can get out of hand fairly quickly. Clients can lie and often will lie. And if you explain to them, for instance, that if you have a felony, that it's really irrelevant to the case unless you lie about it, or if you've committed a misdemeanor or what have you, if you had a DUI previously, none of that is relevant to the case. But if you lie about it, then it becomes an issue, and then it can come in to speak to your truthfulness as a witness. And so the amount of preparation that you take into a deposition, whether or not you're defending or taking, generally speaking, the defending portion, you'll see more attorneys that are more lax in that regard, because you're not really doing much but making those objections. But the active listening piece that Quentin spoke about earlier is extremely important, because if they mischaracterize what your witness said, or what your client said rather, and your client agrees to it, well, I mean, that's on the record. If ultimately they're saying things that help their case and the client agrees to it, that's on the record. If they're asking them multiple times because they want a certain response to their question, and they finally get a response that helps their case, again, that's on the record. So the active listening piece is extremely important, even when you're defending, even when you're not the one taking the deposition. Because experienced attorneys, higher level attorneys will try and take advantage of your inexperience. to a certain degree. But ultimately, if you're a good attorney and you're taking a deposition, you're trying to use whatever angle you can to get information that's favorable to your case. Generally speaking, when you take a deposition, you're doing essentially three things. You're trying to gather information. You're trying to see how this witness is going to present at trial. And then you're trying to solicit information to develop your case. So it's just very important to go in there and be, very attentive, very prepared, and sort of look for the weaknesses in your case before you get in there, so you can prep your client against that if it's a party deposition. Because otherwise, as I noted previously, those type of depositions could greatly undermine the valuation of your case.
And I'll answer Morgan's question quickly. It's our last question. But she says, if someone objects to form for compound question, have you found a judge will absolutely never allow it, or will they break up the question at trial? Do not rely on what you think a judge will do, because, for example, Jeff and I practice in Shelby County, and there are 9 different judges, and they will have 9 different answers to this question. So if you truly believe that it is a compound question, I would just caution yourself and go ahead and maybe re-ask the question and break it up, so that way it is not an issue later, because you just do not want to be at the mercy of a judge when it comes to toss-up questions like that.
Thank you. Thank you for everybody's questions. These are fantastic. If we don't have any additional questions, I will say goodbye to everybody. And again, thank you, Quentin. Thank you, Jeffrey. We appreciate you. I'll be sending everybody certification reminders after this program, and the materials as well, so you have access to that. But thank you all for attending. We look forward to our next webcast. We do have one tomorrow with Holly Floberg, Accounting 101. Holly is also an amazing speaker. She's done a couple with us earlier this year. So tune in, and thank you so much. Have a good day.